Hello and welcome back to the 10,000 Startups Podcast. I am your host, Roger Royce. I am a partner with Haynes Boone, Corporate and Tax. I'm in downtown Palo Alto, and I work with emerging growth and venture capital. And each week on my podcast, we bring you industry experts on a topic of interest of legal matters. And I've been trying for a long time to do this one because it's a topic that affects most startups, maybe all of them eventually. And it's one that I think people might not appreciate the significance of a lot of the issues, and that is real estate leases, commercial leases. And I'm really happy today to have Kelly Bufton here to talk with us. He's senior counsel in our real estate practice group in the Chicago office of Haynes Boone. He has represented clients on both sides of every kind of transaction in the real estate industry, including landlords and tenants. And Kelly is definitely my go-to guy on leases. So first of all, I want to thank you for being here, Kelly.
Glad to.
All right, well, let's jump right into it because, like I said, I work with startups, and almost all of them are going to have, going to confront a commercial lease, even if it's a small one. And I know a lot of companies decide they're just going to wing it and do it themselves. So I got to ask you, when should a company involve a lawyer in the leasing process?
Well, the earlier the better, as far as I'm concerned. Of course, being a lawyer, I want to want to talk to my clients as soon as possible. But I think that it's especially important to understand that when you're negotiating a letter of intent, which is usually how these things start, despite the fact that most letters of intent say that they are not really enforceable, the landlord will look upon the terms that are in the LOI as binding on the parties. And so it's important, even at that point, to have a lawyer involved to at least review the LOI to see if there's anything there that is unusual. Many landlords use their own form of an LOI, and they may try to include in that LOI legal type terms, such as what the assignment and subletting clause is going to say, or what the whether there's going to be a subordination agreement involved. And many of those things it's the first time a client is confronting those issues and really doesn't have the expertise to understand what the ramifications of those are. And I'm sure, Roger, you've run into this, that many times you end up having a client hand you an LOI that's already signed and say, here's what the lease is going to say, and finding that there are terms in there that are detrimental to the client without them really knowing about it.
Yeah,
It's
all the
also,
time.
oh, sorry, go ahead.
Go ahead. No, that's all I was going to say. I agree. I see that all the time.
It's also really important to involve another expert at this time, and that is the broker. Neither we as lawyers nor you as clients have an understanding of the specific leasing market that you're going to be leasing in. And that's what a broker is for, to be able to tell you this is what market standards are about. And it's not only market standards as to the rent, but it's as to what kinds of concessions the landlord is giving, and what other things might be available for the tenant to get. It is well worth your money to get a broker involved as soon as possible. Now, that cost is usually baked into the lease. Sometimes in some markets, here in Chicago, it happens all the time, you can actually negotiate with your broker to have them rebate a portion of their commission to you, so that it may not be as expensive as it may actually look to. So that's another thing to ask about, but it's very important to get a broker involved.
Okay, that was going to be one of my questions. Should we have a broker? It didn't even occur to me to ask for a rebate of part of their commission. So there's a good practice tip already.
It is. I mean, obviously, the bigger the lease, the more likely you are to get that kind of concession. And in small leases, there's less negotiating room, as is true with landlords as well. But in any event, I think there is absolutely no situation where you should not I'm sorry, I get a double negative there. You should absolutely get a lawyer involved at the lease stage if you haven't gotten them involved in the LOI stage. There are a number of legal provisions which will have real impact on you as you go forward in operating your space. And it's really important to see many of those provisions are different from landlord to landlord, from building to building, and can have an impact on you. And it's important to have an expert, a lawyer, look at those terms at least once to go through the lease, even the smallest lease, to point out to you where there may be some things you don't understand that might impact you going forward.
Yeah, gotcha. Yeah, it's interesting that you said the letter of intent will likely be the landlord's form, and the lease will likely be the landlord's form. And I gotta
Oh,
believe
almost surely.
yeah, I gotta believe those things are pretty one-sided as well. So you definitely and hard to read, right?
Well, and it's actually surprising how different some landlords approach leasing. And some leases, yes, you find them that are ridiculously landlord oriented, and other ones you find are much more even-handed and easier to deal with. And it just depends upon particular landlords as to how they want to approach the situation. But this again is something that a lawyer can tell you about, kind of the level of landlord oriented provisions there are in a particular lease.
Gotcha. Well, let's talk about that. What are the major issues that our tenant should be thinking about when they're going to lease space?
Well, first and foremost is, what is it going to cost you? And this goes way beyond what the rental rate is. And usually you'll be looking at different spaces. And so you want to be comparing those the cost of each of those spaces. And it's important that you compare apples to apples in this process. And you make sure that all costs that are involved in a lease are included and understood by you. For instance, one of the biggest issues that I think laymen don't understand about leases is the concept of a gross lease versus a net lease. And even among the industry itself, different interpretations of what that means are out there. And so the key here is what costs the tenant is going to be paying on an ongoing basis, either directly to the landlord or being paid out of the tenant's pocket. Things like real estate taxes. Do you have to pay a pro rata share of your real estate taxes? Do you have to pay a pro rata share of the insurance that the landlord carries on the building? Do you have to pay a pro rata share of the expenses of maintaining the building? And when you talk about maintaining, does it include replacing things? If the roof of the building goes out, do you have to pay a percentage of that? And so those costs, as you might imagine, can dramatically increase your overall operating costs. So when you're analyzing, is this the right lease for me? And how does this compare to the space in building B? You need to make sure you add up all of those costs when you're looking at that. That would also include not only the base rent, but any increases in the base rent. Are there annual increases that go up for the rent? When you're talking about the expenses, no landlord is going to guarantee you what the expenses are going to be going forward. So you should get a good idea of what the expenses have been in the prior years. Get some information. The landlord should always be able to give you information about what the expenses have been for their buildings over the last 2 to 3 years. So you can get an idea of where those numbers are going and what is included in those numbers. As I also said, that the cost of improvements or replacements to the building are important, and whether those are being included in the costs. In many buildings, that can dramatically raise the cost of operating if there's a major cost in the building during your term. Now that will impact you to a greater or lesser extent, depending upon how long your lease term is and how much of that gets passed through by individual landlords. The other
Costs
parts
can
of
be amortized, right, over the term of the
right,
lease.
big costs can often be amortized. You certainly, if you're going to pay them, you want them to be amortized so that you don't, if you've got a, let's say a roof repair that's going to last 20 years and you're only there for 3 years, you don't want to pay the cost of a 20-year roof. You want to pay 3 years worth of the 20-year roof. So that's a very good point, Roger, to make sure that if those kinds of costs are included, and they're not included on all leases, that they are amortized over the term of the reasonable life of that improvement and at a reasonable interest rate. The other things in terms of the cost that you need to think about is there a free rent component? Are you going to get 1, 2, 3, 6 months free rent up front? Now that will bake in. So if you're looking at a $50 a square foot rent, but you get 6 months of free rent on a 5-year lease, then that obviously your effective rent for that entire term is not $50 a square foot. The broker again can be instrumental in helping you parse through that and determining how those numbers are going to work out for you. One of the other costs that you really need to bake into this is how much is it going to cost for me to build out the space? Is the landlord going to build it out? Am I going to build it out? But what is the cost of that? If the landlord is building it out, that cost will be again baked into the rental fee up front. Usually landlords will determine how much it's going to cost. They'll again amortize it over the term of your lease with an interest rate which will be substantially above the normal borrowing rate. That's typical practice. Currently in markets, I'm seeing that landlords are effectively charging 10 to 12% for improvement costs.
What does that
so
mean?
if you
10 to 12% of the lease cost will go to
Oh,
improvements?
no, sorry. Yeah, Roger. So effectively what the landlord is looking at is they're lending you this money to construct the space. So they've become your lender and they're going to charge you, in addition to the cost of the actual cost of those improvements, an interest rate on it.
Oh, I see.
And that'll be like 10 to 12%, and that'll be baked into the rent. So maybe your rent without improvements is $50 a square foot, but your rent with improvements is $75 a square foot. And so you may say, oh, well, I want to take the $50 a square foot rent because it's cheaper. But then you're going to have to put in the money to build out the space. And so you need to figure that in when you're looking at rental rates, if the construction is included or not included. And if you're a good borrower, as I said, the landlord's going to charge you a premium, 10 to 12% interest. If you can go out and borrow that money at 5% to construct the space yourself, you're going to save some money there. It's a trade-off. I mean, you determine what is the easiest way to, whether it is to borrow that money or to have the landlord effectively lend you the money. Another thing you need to think about in terms of the cost up front is the security deposit. Am I going to have to come out of pocket for a big chunk of change in the beginning and have the landlord hold on to that for the term of the lease? The landlords are going to look at your creditworthiness and determining whether you have to pay a security deposit, and if so, how much that is. And so that again needs to figure into your calculations of how much out of pocket am I going to be. One of the things you may want to think about in doing security deposits is, instead of doing cash and having the landlord hold that, where you usually will not get interest, you can ask for interest on it, but usually you will not get interest on a security deposit, but you can do a letter of credit. Most landlords will accept a letter of credit. Some landlords even prefer a letter of credit to cash for bankruptcy reasons. And a letter of credit may be, depending upon the cost of that letter of credit to you, may be a better option financially for you to get a letter of credit as opposed to putting up cash, especially if if you want that cash for your operations. you may want to balance that by doing a letter of credit.
Yeah, so Kelly, can I ask you, are there any rules of thumb on how much or what's the range for a security deposit? What can our tenant expect to be asked to pay?
Well, again, this can vary dramatically, but assuming that the tenant is not a national type credit tenant, so that they are going to have to pay something as a security deposit. Almost all landlords require at least the first month's rent, 1 month rent. I shouldn't say first month's rent because they hold it for the entire term, but 1 month rent is the bare minimum. But the actual number will depend upon also if you are getting tenant improvement dollars up front. If the landlord is expending dollars up front, they want to make sure that that's covered for them. So that that security deposit may in fact have to be significantly larger if depending upon what the landlord is out of pocket when they're going into the lease. So they're looking at that and they're saying, hey, if I have to put $100,000 into this space and your credit is not so good, I want to make sure that I'm going to get that $100,000 back. And so I want a letter of credit from you, or I want a security deposit that's going to cover at least a portion of that.
Right.
But Roger, I've seen security deposits that range from 1 month's rent to effectively 6 or 8 months rent, depending upon the creditworthiness situation and the construction situation. Those are the two big factors.
Yeah. Let me ask you, kind of going on terms here. One of the big issues that I've seen with my clients, especially over the last few years, is how to get out of their leases, how to get out of their space. Because hey, everyone's working at home. We don't need this space anymore. And I have had clients who just said they just abandoned the place. And then they end up being surprised because they have to end up paying all the rent for the lease, which I think is what happens under the lease. Is there a way to not have to, not, first of all, if you want to get out early, and secondly, what happens if you can't get out in time? Are there any things you can do to protect yourself, or what should you watch out for in a lease?
Well, up front, there's a couple of things to do. One thing is in the default section, as you say, often from a landlord standpoint, what the default section says is, look, if you leave the space or you default, you've got to still cover the rent for the entire remaining term of the lease. The landlord wants the benefit of its bargain. Often in the negotiation up front, you can get landlords to agree at the very least to mitigate their damages, which means that they have to go out and try to release the space at the very least. A lot of states, California, Illinois, require mitigation, but not every state. And it's important to know what that situation is. An even better situation is to have what I call pre-mitigation provision in a default section, which says that when the tenant moves out and defaults on the lease, the landlord terminates the lease, the landlord is entitled to a payment that is the difference between what the rent the tenant is currently paying and what the market rent is. So that the tenant is only going to have to pay the difference, and it's only going to have to pay if the rent has actually gone down from the time that they lease the space. Because hey, if the landlord can turn around and lease your $50 space for $75 a space, why should they also be getting money from you? And that's the essence of mitigation. And so that's something that is good to get up front if you can. But it's also, I know that a lot of my clients are uncertain about the size that they're going to need in the future. And usually landlords are wanting 5-year leases at the bare minimum, sometimes 10-year leases. And so tenants can often negotiate up front a right to terminate the lease, either wholly terminate or terminate part of the lease to try to shrink. And again, part of that will depend upon the market. If it's a strong market and the landlord feels that they can release the space fairly easily, then it's an easier get from a landlord. If it's not a tight market, if it's a very weak market, then it's harder to get. At the very least, though, a tenant should expect in that situation that they're going to have to pay the unamortized cost of what the landlord paid out of pocket up front, which would be the lease commission, their legal fees, and whatever construction costs they have. Because that's what that's at a minimum, that's what the landlord is losing by you moving out of the space, because they're going to have to pay those same costs again to put a new tenant in the space. And usually there'll be a 6 month to a year notice on a termination clause, so that the landlord can have that time to relet the space. So that's really a nice thing to negotiate up front. On the other side of the equation, you'd like to have some expansion rights in the event that, hey, your business goes great, or you merge with somebody else, and all of a sudden you need twice the space you had before. It's nice to be able to set aside space that you know will be available at certain points of time in the future that will be adjacent to your existing space, convenient to you, so you don't have to lease something on the 37th floor when you're on the 15th floor. Again, a lot of that depends upon the configuration of the premises, the building, and the market. But a tenant should definitely think about those types of things when they're coming into leasing the space, rather than leaving it until, as you say, 3 years down the road when they suddenly realize they don't need the space, or they need a lot of extra space, and they don't have any negotiating leverage, because there's nothing in the lease that gives them anything.
Right. Okay. Well, is there anything else that the tenant can do to protect itself, especially at the letter of intent stage, before they might have a chance to see you?
Well, again, one of the biggest things I see, I guess I would call it a mistake that tenants do, is in the construction question. And the issue of that goes into the issue not only of who's paying for the construction, but who's going to do the construction. Is the landlord going to do the construction? If so, what's the constraint on the landlord to make sure it gets done in a timely manner? Typically, a tenant is moving out of one space and into another space. And so they want to minimize the time that either they're renting both spaces, or heaven forbid that they have to move out of one space and the new space is not ready. And so one of the things at the LOI stage that is very important, if there's significant construction being done in the space and the landlord is doing it, is to put in some penalties in the event the landlord doesn't make your time frame. And those penalties usually they're in terms of additional free rent. So you get, maybe you've got 2 months free rent. If they're a month late, then you get not only not only does your lease start, but instead of 2 months of free rent, you get 3 months of free rent, or something like that. But the tenant has to think about, if I have to move out of this space, or if I have to hold over in that space waiting for my new space, how much is that going to cost me? And that's where you should determine what the penalty is. And so many leases in your existing space, you'll have to pay 150% or 200% of rent in order to hold over in that space if you don't negotiate something different from the landlord. And yeah, that can be a big nut to crack. And what you're going to want to try to do is put as much of that on the new landlord as you can. They're going to resist that naturally. They're going to want some time to do it. They're going to make it subject to forces outside their control, force majeure. But it's a conversation that definitely has to take place. And all too often, again, in the LOI stage, they put in, hey, the landlord's going to do this and he's going to deliver it, when he gets around to it, basically. And the lease starts when you get around to it. You've got to have some impetus on the landlord to make sure that they're working on that in a timely manner. On bigger deals, where you're talking about, I mean, I did a lease recently with 4 floors in a high-rise office building that hadn't, the construction on the building hadn't even started yet. In those kinds of situations, you have to think about milestones, because otherwise a delay can build up over a long period of time, and you can have a huge delay in the end that you're not aware of. So putting in milestones and saying, hey, you've got to have this done by this date, this done by this date, and having the tenant have a right to get out if those things aren't done by certain dates. But again, that depends upon your bargaining power and the situation. If you're just leasing 1,500 square feet in an office building that the landlord has 150,000 square feet in, then that concern is not nearly so much of a concern.
Right. Hey, can we talk a little bit about subletting? One of the more annoying provisions from the tenant side that I see in these leases is that, let's say the tenant can't use the space, so they sublet it. And it turns out, they make a lot of money on the sublet. And then that clause pops up that said, oh, you got to give the profit to the landlord. That seemed a little,
you discovered that, did you?
Yeah. I mean, the tenant has to take the downside risk if the value goes down, but they don't get the benefit of the upside if the value goes up.
Yeah, I always feel like it's hard for the landlord to justify that, but frankly, the market is such that you almost always have to deal with that at least from a sharing standpoint. Most often, what happens is the parties agree to share that 50-50 if they get an increase. But again, that will depend a lot upon markets. You're in California, I've seen lots of situations where the sublease is at a premium and you get it above what you're paying. In Illinois, in Chicago right now, you're lucky if you get 50% of what you're paying to the landlord. So the question of profit is one that you certainly want to discuss with the landlord. There's also the question of what's called recapture. Recapture is where the landlord has the right to terminate your lease as to the portion you're subletting, or if you're assigning it the entire lease, and take it back, so that the landlord has some protection on again, if the market has gone haywire and you've got lots of profit there, that they may want to take it back. And that's something that can, again, as you say, surprise your tenant. That's the one thing that I really try to emphasize to my clients is I want to make sure that there's nothing in there that's going to surprise them down the road when they come to see that. At the very least, there's a couple of things on sublease. You want to make sure you can sublease to an affiliate entity without any question of having the landlord being able to have to consent to that. You want to be able to sublease to a merger. If your company merges with another company, you don't want that lease and the landlord's consent to that transfer holding up your whole transaction. And so those are two areas where you really want to try to get the landlord to agree basically up front that if you do those, the landlord's going to stay in place. And the argument for that is, look, in either of those situations, the landlord's going to have the same credit that they had before. They're going to have the same entity in the first case, and in the second case, they're going to have presumably a larger entity if it's merged. And so that is something that landlords should agree to. I'm not saying they always do. There's landlords out there that are difficult to deal with, but there's something for tenants, and I think this is true with a lot of your clients, Roger, is that they're in a situation where they're growing, they're changing, they're not sure whether whether mergers are going to happen or whether they're going to have to roll off this piece of their business into an affiliate or things like that. And so it's important to have as much flexibility as they can possibly get in the lease. And it's something, again, that tends to go back and bite people when they're not expecting it.
Yeah, absolutely. Especially on the M&A side. We do a lot of M&A, and it's just so much easier if we could have anticipated this up front than to sit around waiting, can't close because we don't have the landlord's consent and maybe they're non-responsive. So it's nice if we can find something in the lease that gives us a little comfort. And what I often see is, yeah, we'll consent to the merger, but you're gonna have to pay us a fee, for all the trouble to go review this and to look at who the acquirer is, et cetera. But at least that's something.
Yeah, I mean, if in that case, I always try to limit the fee, $1,500 or something minimal, so they can't try to gouge you over it. And of course, we always ask and usually get that the consent will not be unreasonably withheld. That doesn't help you a whole lot, because what are you going to do? You're going to sue the landlord, and it's going to take 6 months, a year to figure out whether or not the court's going to require him to assign it. But it does give you some leverage and some way to go back to the landlord rather than having them just hold up their hands and saying, "Hey guys, I can withhold my consent for any reason, and I've decided I want to withhold my consent." So,
Right.
but it does become a significant problem. One of the other things that I think that tenants need to understand or be careful about, sometimes at the LOI stage, more often at the lease stage, is the landlord's right to relocate you. In bigger buildings, landlords always want the right to relocate tenants in the event that they want to shuffle the stack, so to speak, and move another tenant here and be able to take a whole floor for some other tenant, and they'll move you from the 14th floor to the 17th floor or something like that. And in some situations, a tenant won't care. I mean, in a one-story suburban office building, whether you're looking at the parking lot from this angle or looking at the parking lot from that angle, it really doesn't matter much. But if you're in a high-rise office building in downtown LA and you're on the 37th floor and the landlord wants to move you to the second floor, that's not comparable space in my mind, and it's certainly not what you bargained for, and it's not what you paid for. And so if you're in that kind of situation, it's important to get very strict parameters. If you can't get the relocation clause taken out entirely, it's important to get really strict parameters on that relocation in terms of view, window line, elevator access, certainly the configuration of the space. All those sorts of things need to figure in to make sure you get something that's comparable to what you currently have, so you're paying for the same thing that you think you're paying for.
Gotcha. Okay, well, Kelly, I want to thank you. Is there anything else, any major issues that we want to call out here, being sensitive to your time? Or do you think we've kind of hit the high points?
I think we did pretty well at hitting the high points. I mean, obviously, I think this should impress upon people the need to talk to professionals, both a broker and a lawyer, about even the smallest lease, because lots of these things can come back and bite you if you're not familiar with them.
Gotcha. Okay, well, I want to thank you, Kelly Bufton from Chicago, Haynes Boone, for being here to talk to us about commercial leases. This is Roger Royce with the 10,000 Startups podcast, and we will see you all next week.